Thank you, Gail. Hi, everyone. My name is Hina, and I work within the Research Data Management team at UK Data Archive, and we are based at University of Essex. And today's session is about copyright in publishing and teaching. So introductory part of the session will focus on the brief intro to the intellectual property rights and what are the types of IP rights. Then I'll talk you through to the origins of copyright. And the main session will be run by my colleague Hina, who will talk you through to the copyright issues in the context of publishing and teaching. So intellectual property is something that you create using your mind. For example, a story, an invention, an artistic work, or a symbol. Type of IP rights include trademarks, which is a type of intellectual property consisting of a recognizable sign, design, or expression that identifies products or services of a particular source from those of others. And patents is another type of IP rights. It is an exclusive right granted for an invention. And then is the registered designs. A registered design protects only the shape or appearance of a product. It gives its owner the exclusive right to the design of that product. And the final type is copyright, which is the protection offered for creative works such as books, music, literary works. And you get some types of protection automatically, others you have to apply for. And copyright is the most relevant type in academia, and we are focusing on it today. So you are the intellectual property holder if you have created a work and that work meets the requirement for copyright, patent, or a design. You could also be considered as an IP holder if you have bought intellectual property rights from the creator or a previous owner, or have a brand that could be a trademark, for example, a well-known product name. So having the right type of intellectual property protection helps you to stop people stealing or copying the names of your products or brands, your inventions, designs, and of course, your literary work. So just a quick fun question. Can you guess when the concept of copyright started? You can just write it in the chat box if you can guess. Any thoughts? 1900s? 18th century? Any more thoughts? By Rubens in art. Okay. So no more thoughts? Right. So the cornerstones of modern copyright law, the right to be identified as the creator or the work, and economic property rights have their roots in ancient Greek, Roman, and Jewish cultures and can be traced back as far as 6th century. So in ancient Greece, but it was not until use of the movable type printing press became widespread across Europe that the need for statutory regulation was realized. So the first recorded movable type printing for printing paper books was in China around 1040. These early presses used either ceramic or wooden movable type and were invented by Li Sheng. By the 12th century, China was printing using bronze metal type. There are also records printing in Korea using bronze movable type dating back to the 14th century. I'm not sure whether you are interested in the origins of copyright or not, but I always like to read about the origins of any concept. So that's why I have decided to add, before we go into the concept of copyright in publishing, that we should discuss something about the, not a very detailed information, but a little bit of information about the origins of copyright. So in Germany, around 1440, a goldsmith named Johannes Gutenberg created a printing press that used metal movable type. The type was cast from an alloy of lead, tin, and antimony. And lead, tin, and antimony alloy melts at a far lower temperature than bronze, making it easier to cast. This meant that reusable metal molds could be used to cast the type, making it far quicker to produce the metal type. So a single Gutenberg press could produce around 240 impressions per hour, perhaps 2,000 to 3,000 pages a day, easily 100 times faster than hand printing or hand copying. This drastically reduced the cost of printing. Adoption of this press was fairly rapid, and in 1457 there was a single press in a print shop in Mainz, but by 1480, within 2 decades, there were 110 presses in Europe. Anyone could buy or rent a press, and as there was no copyright law in Europe at that time, new works were quickly republished by competing printers, and this brought about some very positive social changes in the short term. Prices of reprints were low, output grew exponentially, so publications could be bought by poorer people, and Europe saw a swift rise in literacy. So as time went on, European governments set up system of licensing controls over printers, issuing individual printers exclusive licenses to print a particular work for a period of time. This prevented other printers from reproducing the same work during that period, and this had the effect of maintaining a higher price for the work for that period to the benefit of the printer and the author. So as early as 1483 in the UK, Richard III recognized the value of literary works and encouraged the spread of printing, while at the same time seeking to limit and censor texts deemed to be harmful to the church and crown. The Printers and Binders Act 1534 banned the import of foreign works and enabled the Lord Chancellor to limit the price of books. Further censorship was introduced by Henry VIII, who required that all books should be approved before publication. And around 1557, the Stationers' Company received its royal charter from Mary I, giving the company the power to decree who could print books and the right to seize illicit or pirated works. This was not copyright as we understand it today, but rather a rights granted to the printing company or publisher to copy a particular work. So the licensing of the Press Act 1662 built on this framework, entitled as an act for preventing the frequent abuses in printing and unlicensed books and pamphlets, and for regulating of printing and printing presses. Now, the Stationers' Company had the responsibility to censor literary works. The Act had a 2-year duration clause and so had to be renewed by Parliament every 2 years, but censorship led to public protests, and in 1694, Parliament refused to renew the Act. Stationers' Company campaigned for new legislation to restore their role. This failed, but the failure led to an important change in tactic and viewpoint familiar to modern copyright law. So instead of focusing on the printers and publishers, stationers now argued that the authors should have a right of ownership in what they wrote. So this argument persuaded Parliament and led to the enactment of the first Copyright Act, known as the Statute of Anne in 1710. So the world's first copyright law was the statute, I'm sorry if I am pronouncing it incorrectly, Statute of Anne, enacted in England in 1710. So this is the world's first copyright law. This act introduced for the first time the concept of the author of a work being the owner of its copyright and laid out fixed terms of protection. Following this act, copyright works were required to be deposited at specific copyright libraries and registered at Stationers' Hall. There was no automatic copyright protection for unpublished works, and legislation based on this Act gradually appeared in other countries, such as the Copyright Act of 1790 in the United States, but copyright legislation remained uncoordinated at an international level until the 19th century. So in 1886, the Berne Convention, protection of literary and artistic work was held to further protect artists, musicians, photographers, designers, and so on. The main aim was to provide mutual recognition of copyright between nation states and to promote the development of international standards for copyright protection. So a fundamental new principle was laid down, namely that copyright automatically exists from the day a creative work is available in a tangible form. And it also states that the creator of a work does not need to apply for copyright or to register it. It is automatically granted once it has been put into a fixed form. One of the biggest changes implemented by the adoption of this convention was to extend copyright protection to unpublished works and remove the requirement for registration. So in countries of the Berne Convention, this means the countries who follow this convention, in those countries, it means that an individual or the organization they are working for owns the copyright of any work they produce as soon as it is recorded in some way, be it be writing it down, drawing, filming, and it also formulates rules regarding the copyright duration, copyright permission, and expects all signatory nations to incorporate the law in their national law. So the Berne Convention does away with the need to register works separately in each individual country and has been adopted by almost all the nations of the world. Over 179 countries are its signatories. So this convention remains in force to this day and continues to provide the basis for international copyright law. The main advantage of the treaty is that if copyright exists in one of these countries, then this copyright is valid in all member countries. This means that copyright automatically protects your work at a worldwide level. So just out of interest, I found a list of the countries that are not the members of this convention. And this is the list. These countries may be members of other international treaties or may have national copyright laws, but they are not members of the Berne Convention. So just bear in mind that though details of national laws may differ, the basic rights are the same in most countries due to international conventions and agreements. So thank you very much for listening the origin of copyright. And there is an upcoming workshop next Friday, how copyright plays a role in the context of research data. So if you are interested in that, please sign up. I will provide a link in the chat box later. So thank you very much, and over to you, Hina.
Hina, just to let you know, I think there was actually one question in the Q&A box. Don't know if you want to have a look at that.
In a Q&A box? Okay.
Yeah, can you see that?
Yeah, so the question is, are data protected by copyright? For example, if I come across a data set online, perhaps to do with the football results, do I need permission to use that? Yeah, so the next session is about the research data and copyright, but just to answer this, you need to see the terms and conditions of the website or the database from where you are getting that data. Usually people or researchers, they are allowed to use the data for their personal use, but when it comes to sharing their data, they are not allowed to deposit that data in a repository. So first thing you need to consider is that if you are planning to share that data, then you need to check their terms and conditions, whether you are allowed to deposit that data or not. But if you are using it for your own personal research and you don't have any plans to share the data set, then you do not need to ask for the permission. I think it comes under fair dealing. People are allowed to use content under fair dealing exemption, but definitely need to ask for the permission if you plan to share. Okay, thank you. Is there any other question?
No, not that I can see at the moment. So thank you for that.
Okay, over to you, Hannah.
Great, thank you. Thanks, Hina. I'll just share my screen so you guys can see my slides. Okay, hi everyone, good morning. I'm Hannah Crago and I work in the library at the University of Essex and I'm the Scholarly Communications Coordinator. So I work quite a lot with copyright, mostly around research, but also around teaching. So that's what I'm going to be speaking about today. So first of all, I'm going to give a kind of basic introduction to copyright in publishing and different copyright considerations that you need to make when you are publishing your research. Then I'm going to speak about some of the copyright considerations when teaching, so things like copyright licenses and copyright exceptions that can help when you're creating lecture materials or adding reader materials to virtual learning environments, those kind of things. So the first half is going to be a lot of me talking, but in the second half of the session, we're going to do answer some common copyright questions together. So based on some of your prior knowledge and also based on the content that I'm going to be sharing with you, I'll run some polls in the Zoom meeting so you guys can help answer some common copyright questions together, just to build your confidence around answering copyright questions and also kind of have some of those discussions that come up most frequently when it comes to making copyright decisions. Okay, if anyone does have any questions as we go through, please do feel free to put them in the Q&A. I'll probably mostly come to them at the end, but I'll keep a little eye on that as well in case there's anything to answer immediately. Okay, but first of all, let's think about copyright in publishing. So when it comes to copyright with publishing, it's important to keep copyright in mind right from the beginning of the publishing process. So right from when you start creating and writing your manuscript, keeping copyright in mind from the start will save you lots of time and effort in the long run. So because when you're going to publish a manuscript, the journal or the publisher expects you as the author to sort out all of the clearance for any third-party material and give appropriate attributions to any third-party material that you might be using. So we're thinking here about things like images, figures, tables, graphs, those kind of things that you might be using from another person's work within your own work. We're not talking here about short quotations. Using quotation within research is obviously very, very common academic practice, and this would follow the usual kind of quotation and referencing format within your work. You wouldn't need to be thinking about copyright for individual small quotes. We're talking about substantial work here, so substantial materials such as those images, figures, graphs, etc. But where you are using third-party material, it's up to you to clear the copyright for that material and give those appropriate attributions. So the way that you need to go about that and other different copyright considerations when publishing vary, depend on how your research is published. So the way that you're publishing your research affects the copyright implications for that research. So we're going to be looking today at a few different ways of publishing and the way that copyright affects that. So we'll look at subscription-based journals, open access journals and hybrid journals, and then briefly at books and open access monographs as well. So first of all, subscription journals, which probably is still the most common way of publishing academic research, although academic journals are certainly growing at a very rapid rate at the moment. But when we think about subscription-based journals, usually you as the author will sign a copyright agreement with the publisher when your paper is accepted. And through those terms and conditions that you sign, it's very likely that when you're publishing in a subscription-based journal that you sign over the copyright to the publisher. So that means that the publisher will then own the rights to your work. You no longer own the copyright to that version of the work, and that will then affect how you're able to use that work in the future. So usually when you sign these copyright agreements when publishing with a subscription-based journal, as I say, you sign the rights over to the final published version, but usually you as the author will keep the copyright to the author's accepted manuscript, which is also known as the AAM. And this is the version of your paper before all of the journal formatting and the kind of the header and those sorts of things are added, but after peer review. So it will be the final content of that paper, but it won't have the journal formatting and all of those kind of things, which is known as the version of record. However, even though you retain the rights to that author's accepted manuscript most of the time when publishing in a subscription-based journal, there very often are still restrictions in terms of what you're allowed to do with that author's accepted manuscript. So usually when you're signing that copyright agreement with the journal, you will be signing to say that you won't deposit the full text of your author's accepted manuscript on a public website until a certain amount of time has passed, and this is known as an embargo period. So that means that if you wanted to make your paper available open access via an institutional repository, for example, you wouldn't be able to do that until that embargo period has passed. And this can vary, normally anything between 0 to 24 months, but it can even be up to 36 months in some situations. So it's really important when you're publishing with a subscription-based journal that you read through that copyright agreement before you sign with the publisher and before your work is published, so that you fully understand the implications of that agreement that you've signed. If, for example, you'd signed to say that you wouldn't make the full text of your author's accepted manuscript available for a certain amount of time, and then you did, you'd be in breach of your agreement with that journal, which could lead to problems. Usually it would just be to ask you to take it down, but it could potentially have legal implications. So it is important to understand those. I know in life we tend to be presented with lots of terms and conditions, and you might be used to scrolling to the bottom, ticking yes and going ahead with your day. When it comes to publishing your own work, please do take the time to read those copyright agreements. They are important. And it's also important to read those copyright agreements because actually in some cases journals will allow you to request a change to their standard copyright agreement. So you will normally be presented with the standard copyright agreement there when you publish your work, but you could request that to be changed before you sign it. So you might say that you want to request that you are able to deposit the full text within a repository, for example, and then your journal could come back to you on that. There are actually lots of changes at the moment around this kind of area due to funder policies and what's known as the rights retention strategy. And that's something I'm going to speak a bit more about in a moment. But one to remember that if you are publishing in a subscription-based journal, it is possible to change the standard copyright agreement. Thinking about open access journals though, in comparison to subscription-based journals, when you're publishing in an open access journal, usually the author will keep all rights to their work, including that final published version that we've just been talking about. In these situations, you as the copyright holder then usually give the journal a license to publish. So you retain the copyright, but you sign some paperwork to say that you're licensing the journal to publish that work on your behalf as the copyright owner. You'd also then give that version of the paper a Creative Commons license, and that was how it would be openly licensed. And I'm going to come on to talk about that in a moment. In terms of hybrid journals work in a way that they're basically a hybrid between a subscription journal and an open access journal. So with a hybrid journal, most of the content will be behind a paywall, so will work as a subscription-based journal would. But at the same time, some papers within that journal will be made available open access. So individual authors can pay article processing charges to make their individual papers open access within that journal, even though most of the content will remain behind a paywall. In terms of copyright, what that means is within hybrid journals, there's two situations really. If you pay to make your paper available open access within a hybrid journal, then you will retain the copyright as the author, like you would when publishing in a fully open access journal. And as I said, when we spoke about fully open access journals, you would give the journal a license to publish your work, and a Creative Commons license is attached to the work with all the rights remaining with you. However, if you publish traditionally and within the hybrid journal, so behind a paywall, it works the same as the subscription journals we just spoke about. So copyright would usually be transferred to the journal. So when publishing open access, whether that be in a fully open access journal or whether that be within a hybrid journal, making your paper available open access, your journal article will be given a Creative Commons license, or more accurately, you will assign your paper a Creative Commons license. So Creative Commons licenses are different levels of open access, and they have these different layers within them. And these different layers can be seen within the table on the slide, and they can be combined in different ways. So I'm just going to briefly run through these. As you add different layers, you get different levels of restriction on your work. So a license that I haven't shown on here because it doesn't usually come with academic journal publishing, but a license you might be aware of is a CC0 license, which means that there are no rights reserved and a work is termed as being in the public domain. It can be reused, however, without needing any attribution, and that would be the least restrictive Creative Commons license, the CC0 license. As I say, I haven't included that on the slide because it doesn't usually coincide with academic publishing. The least restrictive license that usually coincides with academic journal article publishing is a CC BY license or CC BY license or CC attribution license, whatever you want to call it. And what this license means is that reuse is allowed, so anyone can reuse a work with a CC BY license on it, but the author or the licenser must get full credit for that work, so attribution. They must say that it's based on a certain, it's based on a work created by this creator, and that would be the attribution. The second layer that you can add is a CC BY SA license, with the SA standing for share alike. And that means, again, attribution must be given. So all of the CC BY licenses require attribution. But the SA share alike element means that licensees are allowed to distribute a modified version of the work. So they can modify the work and distribute that how they like, but it must be only under the same or not more restrictive license as the original work. So if I was creating something based on a work with a CC BY SA license, and I created something based on that work, I couldn't then make my creation a all rights reserved license, for example, because I would be making that more restrictive. And that isn't what the original copyright holder of the work I've based mine on wanted, because they put a share alike license on there. Another element you can add to a Creative Commons attribution license is the NC element, which stands for non-commercial. And that means, again, that reuse is allowed with attribution, but only for non-commercial purposes. So if you're using a work or distributing a work with a CC BY NC license, you can't make any money from it. So that does have implications that might be more obvious, like you couldn't write a book based on a CC BY NC book and then sell that book. But also it does have other implications, such as you couldn't use CC BY NC work within a conference presentation if you were being paid to be at that conference, because that would also be deemed as a commercial purpose. So there are implications with that license that can be quite restrictive, and is something to consider if you did want to put a CC BY NC license on one of your own works. The final license, which is the most restrictive of the CC BY licenses, is the CC BY ND license, and this stands for no derivatives, and that means that no modifications are allowed to that version of the work. So a work with a CC BY ND license can be reused and redistributed, but only in its original form. It can't be modified, it can't be changed in any way, it can't be translated into another language, for example. There's lots of different ways that that would be restricted. So a CC BY ND license would be the most restrictive layer of the Creative Commons licenses. I should also say that these licenses that I've been through, those are the 4 different layers, but they can be combined in different ways. So for example, we've got here CC BY SA, CC BY NC, but there could be a CC BY SA NC, so it might have the share alike and non-commercial element, or the non-commercial and non-derivatives element, for example. So they can be combined in different ways. It's the CC BY base that will always need to be there though. So in terms of publishing, as that's what we are talking about these licenses in regard to, when you're publishing your paper open access, usually your journal will stipulate a standard Creative Commons license that they assign for their open access papers. They might have a choice, especially in the humanities. It's more common that some of the more restrictive licenses are used. But it's also important to be aware that if you are publishing funded research, then sometimes funders can also stipulate what license you need to be putting on open access versions of your work. So do make sure, if your research is funded, that you are looking at your funder policy, and I'm going to come on to that in more depth in a moment. So thinking about funders and the way that research funding can affect copyright decisions, funders increasingly, so research funders increasingly are asking for open access publication. And this is specifically grown as a result of Plan S, which is a strategy or a set of rules that has been created by Coalition S. So Coalition S are an international consortium of research funders, so a group of research funders, and this group includes funders such as the European Commission, Wellcome, and also UKRI. They're just three of a fairly large group, and any funders that are part of Coalition S must abide by Plan S, which is this set of rules which aims for full and immediate open access to all publicly funded research. So I'm not going to go into too much depth on this now, because we do want to keep the focus on copyright in this session. But basically, if your research is funded by a Coalition S funder, so for example, Wellcome or UKRI, there's three ways that you are able to comply with your funder's open access policies. One is to publish in a fully gold open access journal. One is to publish under what's known as a transformative agreement or a read and publish agreement, which are agreements between institutions and publishers that cover open access publishing. But it's the third route which is most important to us today in terms of copyright, because the third route to comply with your funder's policy, if your funder is part of Coalition S, is to publish via the green route to open access, so to self-archive your paper within an institutional repository, for example, but there must be a 0-month embargo period. So this is really important because Plan S wants full and immediate access to all publicly funded research. So that immediate means that in the past, lots of self-archiving has taken place with embargo periods. So that would be where I said earlier that if you're publishing in a subscription journal and you retain the rights to your author's accepted manuscript, but your journal might stipulate that you can only make that author's accepted manuscript publicly available after a certain length of time, after that embargo period. If your research is funded by a Coalition S funder, this is no longer permitted because they insist that the full text of your paper must be immediately available for everyone to read. So there must be a 0-month embargo period. This funder policy has caused mismatches between journal and funder policies. So imagine, for example, your research is funded by the UKRI, and they're saying there must be a 0-month embargo period on your research if you're publishing in a subscription journal. At the same time, the journal you're looking to publish in, this subscription journal, is saying that you can't make the full text of your work available for 6 months after publication. That's a mismatch there. And if you haven't read and understood both your funder policy and your journal policy and have signed both, then you'll be in breach of one of those contracts because it's impossible to comply by both. A way around this situation, firstly, is to make sure to read all of your policies before you sign them. But what funders have come up with, so what Coalition S have come up with as a way around this, is known as the rights retention strategy. So the rights retention strategy is a statement for authors to add on submission to journals. So you can see the statement on the slide here. So it's just this short bit of wording. And what this is that if your research is funded by a Coalition S funder and you're publishing in a subscription journal, you need to put this statement on your paper on submission to that journal. And what this statement does is that it tells the journal that you as the author are retaining the copyright on the author's accepted manuscript, which, as I said earlier, is common practice, but you're taking it a step further because you as the author are applying a Creative Commons Attribution license, so you can see here on the slide the Ccby license, on that author's accepted manuscript. You're telling the journal that, on submission. So this is known as a prior license because you're putting a prior license on that version of the work that doesn't actually exist yet, but you're asserting your rights as the current copyright holder by saying any author's accepted manuscript that arises from that submission to the journal, you are licensing with a Creative Commons Attribution license. In practice, what this means is that you are able to share and reuse that paper, that version of the paper at least, however you like, and anyone is able to share and reuse that paper however they like, as long as attribution is given to you. That therefore means that you would be able to deposit that author's accepted manuscript within an institutional repository with a 0-month embargo period because you own the rights and it's been shared in this open access way. That means that regardless of what the journal policy says, your prior license that would be applied due to this statement will overrule any journal policy. So this is kind of like a backstop for authors. It enables authors to keep the rights over this version of their paper, regardless of what the journal stipulates, allowing them to be able to make a version of their paper open access. So it's really important. It's a really big step in copyright. It's a really big step forward for authors in terms of keeping copyright on their papers. And this statement, as I said, is important for complying with funder policies, but it doesn't have to be used by funded authors. Anyone who is publishing, whether they're funded or not, can put a statement like this on their paper on submission to a journal and retain the rights over that version of their work and license it in this open way to enable them to use it how they like in the future. Okay, so what I've spoken about so far has been a lot around journal articles, but I'm going to speak a bit now about monograph publishing and book publishing, because this also has a lot of different copyright considerations. So if you're publishing a book, usually the publisher will ask the author to assign certain rights to the publisher. So there's three main ways usually that book publishing works in terms of copyright. So the details of agreements can differ quite a lot between publishers. So again, do make sure you're reading those copyright agreements before signing. But the three general situations that occur are, the first is that you might assign the copyright. So like with a subscription journal, the publisher now owns the work, but you as the author with book publishing would usually get royalties or payment for sales of that work. The second that can be quite common is exclusive rights. So you as the author would keep the copyright, but you're giving the publisher exclusive rights to publish your work. So you wouldn't be allowed to publish or disseminate the work at all elsewhere because that publisher has exclusive rights. The third is non-exclusive rights. So slightly different to exclusive rights in that dissemination is allowed. So in these situations, you'd probably be able to put the work in a institutional repository, for example, because that would be dissemination rather than republishing. But republishing is still usually not allowed. So you wouldn't be able to sell your work to two different publishers in most situations with that one. You can also publish books and monographs open access, and this would be the same concept as an open access journal. So you would retain the copyright and your book would be published under one of those Creative Commons licenses. Open access monograph publishing, however, is somewhat behind open access journal publishing, but again, funders are starting to ask for open access monograph publishing too. So that could mean rights retention strategy might become relevant here too. We're not really sure yet, but it is also looking likely that embargo periods may be permitted for monographs where research is funded. So it's sort of a watch this space situation with open access monographs. They are increasing, but they're still a very long way behind open access journal publishing. Okay, so those are the main things I wanted to speak about in terms of copyright considerations when publishing. Hopefully that has answered more questions than raised, although I do appreciate that it can get quite complicated, especially with the funder requirements. As I say, we will have time for questions at the end. But what I'm going to speak about now is how copyright affects teaching. So when we think about copyright implications for teaching, copyright can affect what kind of resources can be used in teaching materials. And it can also affect what can be included on online reading lists or within virtual learning environments. So there are lots of different, well, no, not lots. There are a few different licenses that are available for education, and particularly in higher education, that are common within the UK. So this is what I'm going to focus on first of all. The first of these is the Copyright Licensing Agency license, also known as the CLA license, and this is specifically for higher education. This is a license that lots of UK institutions will have signed up for, or paid for, more accurately, within the UK, as it allows UK higher education institutions, to copy from books, journals, and magazines, specifically for educational use. So under the terms of this license, for signatories of this license, materials that are covered, and this is the important point, so there is a kind of list, I guess, of materials that are covered by this license. For materials that are covered by the license, up to 10% or one chapter of the work can be copied, whichever is greater. Or where we're thinking about journal articles, one article from that issue of that journal can be copied under the terms of that license for educational use. So that for educational use element is really important. So copies can only be shared with students and staff that are registered at the institution. And usually this is monitored by the copies that are made only being circulated via password protected platforms. So usually reading list platforms. At the University of Essex, we have Talis Aspire, but there are lots of different reading list platforms, or they might be shared via virtual learning environments such as Moodle or Blackboard, those kind of things. But usually the scans made under the terms of this license will be password protected to ensure that they're only being shared with students and staff. Also, by using platforms such as these, particularly when thinking about online reading list platforms, often reporting to the Copyright Licensing Agency takes place via these platforms, because all scans made under the terms of this license need to be reported annually to the Copyright Licensing Agency to ensure that copyright compliance is in place. So at the University of Essex, as I say, we use Talis Aspire as our reading list platform, and that has a digitisation element to it, which enables all of our scans and all of our scanning to be reported all but automatically to the CLA. And this would be common for most institutions around the UK. There are, so yeah, that will be the main license for education that is used for reading materials, whether it be books, journals, magazines, all of those kind of things. Another license that is used for teaching within the UK is the Educational Recording Agency license, or the ERA license for higher education. And this license enables staff and students to record or make copies of programmes, so broadcasts for educational use. It can be radio or television broadcasts. Again, educational use is really important here, so copies can't be made just for entertainment or for any kind of commercial activity. It must be strictly for educational use. But this license allows programmes or clips of programmes to be shared again on virtual learning environments or online reading list platforms, and also embedded within presentations, for example, within teaching resources for a lecture or a seminar. And it also, the Educational Recording Agency license for institutions that have signed up to it, it does allow institutions to subscribe to Box of Broadcasts, which you might be aware of, which is a database of broadcasts made within the UK. So many programmes and films that have been broadcast in the UK are available within Box of Broadcasts, and others can also be requested on that platform. And all of those copies are made under the terms of the Educational Recording Agency licence. There have been complications during COVID with the Educational Recording Agency licence, mostly because the ERA licence only applies to the UK and since COVID to the EU, although again, that's looking like it may be further complicated by Brexit, but we won't go into the politics of that. But where it only covers use within the UK and EU, where lots of teaching has moved online, and particularly during the height of the pandemic, where lots of students had travelled to different countries, there were lots of questions about whether students could still make use of these broadcasts and recordings in different countries. There was also lots of questions around whether films could be broadcast via Zoom in teaching sessions, or whether that was then seen as a step too far copyright-wise in terms of distribution. The general consensus in the copyright community was that yes, Zoom teaching sessions are just an extension of the classroom and therefore that should be okay. But there were then technical issues over kind of quality. And if those recordings then weren't commercially available online, compromises were made, and there was a lot of back and forth around the Educational Recording Agency licence during COVID. But in terms of copyright, it was sort of a risk management approach. And what lots of institutions did was they ripped DVDs and released them to students via the virtual learning environment just for a short period of time. And they saw that as kind of a risk managed approach to the situation. And this risk management is something I'm going to come on to in a moment when talking about copyright exceptions. Oh, this moment. So I've just spoken about the CLA license and the ERA license, which are licenses that we use for teaching, but there are also some copyright exceptions within UK copyright law that can be used for teaching. And the most important of these would be section 32, which is termed as illustration for instruction. So where the sharing of materials isn't covered by one of the licenses I've just spoken about, as educators, we can refer to copyright exceptions when it comes to teaching. So there are various copyright exceptions we refer to when making decisions for teaching, but section 32, as I say, is the most relevant, where we're thinking about illustration for instruction. So the usual kind of fair dealing questions apply with this exception. So we need to think about, with section 32, it's specifically for instruction, so for teaching. It's non-commercial. It purely must be for instruction, and there has to be significant acknowledgement. This fundamentally in itself, as with many things in copyright, is open to interpretation. Non-commercial, for example, seems really straightforward. We don't want to be making money from the resources. Seems like that should be an easy one to answer. But where we're charging students for an education in UK higher education, is this non-commercial? We are charging students a lot of money to be at university. Can we say that it's non-commercial? Generally, the consensus is yes, universities are not-for-profit. So generally, education within higher education is deemed as a non-commercial activity, so that one is fine. The other element of this exception is the for instruction aspect. So sometimes in the past, this has been interpreted as just for in-class materials. However, over the past 5 years really now, maybe more, but especially over the past 2 years, online platforms such as reading lists, virtual learning environments and online classes are just an essential part of teaching, and they're deemed as an extension to the classroom. So you can use this copyright exception for uploading materials to virtual learning environments, etc. But copyright exceptions are more restrictive than making materials available under the terms of those licenses I've just spoken about, because we need to think about fair dealing, which is a fundamental element of UK copyright law. And the general questions that we think about here are, is the material used and the use directly relevant to what is being taught? So it must be directly relevant to use this illustration for instruction exception. It can't be just a nice to have or an image that's nice for decoration. It must be directly relevant to what is actually being taught. Also have to ask ourselves whether we're reproducing an unreasonable proportion of the original. So we don't want to be making a copy of an entire chapter of a book if actually we only needed pages 4 to 6. So we have to be reproducing a reasonable proportion of the work. So if you are, so we want to think about, is the use of that copy really a replacement for purchasing additional copies, because that then wouldn't be deemed fair to the copyright owner. If you are scanning a whole book and giving it to all of your students who would otherwise have bought copies of that book, or otherwise whose library would have bought more copies of that book, that would be detrimental to the copyright owner. You also have to think about whether it could damage the interests of the copyright owner in any way. Usually the answer would be no with education, but it's always good to think about that as well. And the most fundamental of fair dealing, have we acknowledged the author and the source adequately? So acknowledgement is absolutely crucial, and redirecting people to the original, again, is crucial. A good rule of thumb when you're making use of copyright exceptions is to put yourself in the position of the owner of the copyright and think about whether you would be happy with your work being used in that way. So we've just been speaking a lot about copyright for publishing and thinking about our own work being published and reused. So when it comes to teaching, imagine that it's your work being used. Would you be happy with the way it's being used, or would you not be? If you wouldn't be, chances are the copyright owner wouldn't be either. So this can be a really good rule of thumb for copyright. Okay, so I've spoken to you guys for quite a long time now. So I wanted to get your input a bit with some of these questions around copyright. So what I'm going to do is I've got a series of common copyright questions that we get asked here within our research support team at the University of Essex. And I wanted to use a Zoom poll to see what you guys think to these different scenarios. So for each question, there's going to be the same three options. So we're going to have the options yes, no, and it depends. And I'll ask you to respond to the poll. And then if you could put any thoughts that you have on that or reasons why you've answered how you have in the chat, and we can get a bit of a discussion going. I'll try to pick up some of those and we can talk them through as well. And I'll tell you what I think too. So the first question is, do I own the right to my PhD? So imagine that you are a PhD student, you may be a PhD student. Do you, as the author, own the rights to your PhD? So we've got yes, no, or maybe. And I'll just give you a minute or so to answer that. I'll give you 30 seconds actually for each one because I've got a timer. Okay, so let's see the results. So we had a mixture of yes, no, and it depends. Did anyone want to put in the chat their thoughts on why they answered in that way? So what do you think? Why do you think yes, that you do own the rights, or why do you think no, or why might you think it depends? I'll give you a second and then I'll let you know my thoughts. Oh, I see we've got a, does it depend on choosing a license when it's copyright checked and completed? So that would be the case if you were publishing your thesis. However, when we think about just writing your PhD and then it being submitted to the university for assessment, usually they wouldn't be published, so they wouldn't have a license assigned to them. So I would say that the answer with this one, here at the University of Essex, the answer is yes. So at Essex, we say that PhD students are students at the university. They're paying to be here at the university and therefore they own the rights to their PhD. However, it could be that at your institution, the answer is no. So really the answer here is it depends. It depends on the policies of your institution, though I would say that most commonly within the UK, PhD students do own the rights to their thesis and they own the rights to their output of their PhD study, usually because they are paying to be there. This might have given you a clue for the next question, which is, sorry, not this next question, I got the order wrong. They might give you the answer to a question coming up, but this second question, can I use images I don't own in my PhD thesis? So I've got yes, no, it depends. So again, you're writing your PhD thesis, there's an image that you don't own that you want to use within your thesis. Do you think that you can use it? Just give you a few more seconds for those still thinking. And feel free to put your thoughts on this one in the chat as well. Okay, so we've got I can, but only if I get copyright clearance from the image holder. I'm going to end the poll now and share the results. So we've got mostly people said it depends for this one. I would say that in terms of your PhD thesis, the answer is yes. So there is a copyright exception for education and research, and that means you can use a reasonable amount of published works for education and research as long as that image is properly cited. So again, this comes down to whether it's going to be published or not. So the answer we got in the chat here, I can, but only if I get copyright clearance from the image owner. That is completely right and a really good answer if the work were going to be published. So if you were going to publish your PhD thesis. If you are just writing your thesis for submission for education and research, you wouldn't need to get copyright clearance for the image owners. However, lots of people do publish their PhD thesis. Lots of people do upload them to institutional repositories with the full text. So I would really say that it's very good practice to get copyright clearance for any third-party material you're using in your thesis, because if you do want to go on to publish it, and we've had situations in the past with PhD students here who have completed their thesis, they've had third-party material in there, they want to then go on to publish it, and they can no longer remember where they got that third-party material from. They can't get the copyright clearance, and those parts have just had to been redacted from their work, which is a problem. So technically, in terms of copyright law, no. Well, yes, you can use images you don't know in your PhD thesis, because there is a copyright exception there for education and research. But I would recommend always getting copyright clearance or using open access images with licenses that allow you to reshare them. Because if you do want to go on to publish your work, it makes it much easier further down the line. Okay, next question. This one I may have just given you the answer for. So can I include the images I used in my research in my publication? So you've written your PhD and now you want to publish your thesis. You're publishing based on your thesis and you want to use the images that you used in your PhD research within your publication. Again, any thoughts or reasonings you have, happy to have that in the chat to discuss. Although the previous comment might be the most relevant here. Okay, so we've got a lot of it depends. So yes, it depends. As I've just said, publication is different to research. So once you publish your PhD, you must think about any third-party materials that you've used. And as I just mentioned, use open access resources as a way to help, because then they're able to be shared, or you'll need to seek permission from the copyright owner. So the answer that the person put in the chat, sorry, I can't see your name very easily with the way I've got my screen. You can, but only if you get copyright clearance from the image owner. 100% correct, this one, yeah. Unless it's an open access resource, in which case you wouldn't need to get copyright clearance. Okay, the next one. Can I reuse content from work I have published before? So you've published a journal article in the past and now you're writing your second article. Can you reuse content from the work you've published before? Again, any thoughts welcome in the chat. If you've got a lot of it depends coming through, if you want to put some of your reasoning of why you think it depends or what situations it might depend on, that would be great to hear. Depends on the license of the former work, yes. Dependent on the type of copyright, exactly, yes. So if I share the results, we've got mostly it depends and one yes. So yes, as the people in the chat have said, it depends on the type of copyright of the previous work or the license of the former work. So do you still own the copyright to your previous work? If you've published in a subscription journal and you've signed over copyright to the publisher, then it doesn't matter that you've written it before, you no longer own the copyright. So you would still need to clear the copyright with that copyright owner now, because you are no longer the copyright holder. Great, thank you. I've just seen in the chat someone's leaving. If you do still own the copyright, so if you've published your previous work under an open access license, then you would be able to reuse it. In both situations, though, you still need to self-cite. So even when you're using your own previously published work, you still need to cite yourself. You still need to give attribution to your own work. And self-citation is just as important as citing other people. Okay, next one. Can I reuse figures from my published work in future works? Again, any thoughts welcome in the chat? Getting quite a lot of it depends coming through. Might be similar to the previous one, perhaps. Okay, so we had lots of it depends and a few yeses. So as I kind of hinted at, it's similar to the previous answer. So again, yes, it does depend. Do you still own the copyright to those figures? If you do, yes, so numbers and measurements aren't, as far as I'm aware, covered by copyright, but I'm talking about if you created graphs or tables and those kind of things, then they would be protected by copyright. And a way that you can, so if you've published those figures previously in an open access way, then you would be able to reuse them with self-citation. But a really good thing to do if you're creating figures with your research, before you publish a work with those figures in, so before you say publish a journal article with those graphs in, you can upload those graphs or whatever figures they might be to platforms such as Figshare. And then when you've put those on Figshare, you can license those figures individually. So you could give your figure a Creative Commons attribution license that would then allow you to retain the rights on that figure. And then if you were to publish with that figure in a work that was you signed the copyright over to, you wouldn't sign the copyright over to that figure because that figure has already been prior licensed as an open access resource with yourself as the copyright holder. You would then effectively have to ask your own permission to put that figure in your published work, which obviously you would be able to do because you own the copyright. So using Figshare for your figures can be a really good way to retain the copyright on your figures and graphs, other things that you might be creating during the process of your research, that allows you to keep the copyright of those even if you sign the copyright over for your published paper. Okay, the next one, we're thinking more about teaching. So can I put my reading materials on a virtual learning environment? So can you upload scans of book chapters, journal articles, whole books, all of these kind of things onto your virtual learning environment? Again, any thoughts in the chat if you have any? We're getting quite a mixture of results this time. Okay, so we've got a mixture of results here. This one really does depend by institution. Different institutions have different policies on this kind of thing. Here at Essex, we ask that all reading materials are uploaded to our reading list platform, so Tell Us Aspire, because we make scans under the terms of our our copyright licensing agency license, and all reporting for that happens via our online reading list platform. So the answer here at Essex would be no, because our scans all need to go on our online reading list platform. However, at other institutions, they might use virtual learning environments like Moodle or Blackboard to host reading materials. So it really does depend on what your institution is. But the important point here is that scans do need to be made under the terms of the license that your university has. And there needs to be a mechanism in place for reporting if you're making those scans under the terms of the license. You can use a copyright exception, as I mentioned earlier, but it is more restrictive than the copying that can take place under the copyright licensing agency license. Okay, the next one. I wrote the chapter so I can do whatever I like with the full text. Got yes, no, it depends again. give you a few more seconds with this one. Okay, so we've got mostly no's, but also some it depends. The answer, I guess, really is no, you can't do whatever you like with it because it will always depend on the license of the work. But I would say it depends because it depends on if you own the copyright. If you do own the copyright to the chapter that you've written, in effect, you can do whatever you like with it because you will have assigned the license to it. So you have to abide by the license you gave it if you own the copyright. So if it's a CC BY ND license, you couldn't make derivatives of it because that's what the license you gave it. If you don't own the copyright though, then whether you've written it or not, it doesn't matter anymore because you no longer own the copyright. So one question that we get quite a lot from our academics here at Essex is they can feel quite frustrated if a chapter that they've written, we then can't scan and upload to a reading list if it's not covered by our Copyright Licensing Agency license because they think that because they've written it, they should be able to do whatever they like with it. But unfortunately, if you do sign the copyright over, you lose that right to be able to do what you like with it, unless you've still got a preprint version of which you will likely always own the copyright to. But those published versions, just think about the implications if you are signing over copyright. Okay, we've got a few left to go. So it's freely available online, so I can share it with my students. So we're thinking here that if you were creating some teaching materials for your module, you found a resource that's freely available online, so you can absolutely share it with your students. What do we think? Got a mixture of results coming in this time. Okay, so as I say, we've got a mixture between yes, no, and it depends. Only one no, but we've got a mixture. This one, again, I would say it really depends because not all materials that are freely available online are legitimate. So in some cases, if it's a legitimate open access resource, then that's great. It's freely available online. It's great to share with your students. However, if something has been illegally scanned and uploaded or illegally recorded, we wouldn't want to openly direct our students to this source. We have a responsibility as an institution for copyright compliance, and it risks reputational damage to openly direct students to illegal resources. If you imagine from years ago when people would take film recorders into cinema and record a film, imagine that was found on YouTube. I don't think you'd want to direct your students to that. It's very clearly illegally uploaded. The same could be said for clearly illegally uploaded reader materials. We can't openly direct our students to the source. However, this is a really difficult one for our team within the library, really, because we don't want to stop people accessing the resources they need. Our main job is to get students the resources that they need. So it is really frustrating for us because we can't police the internet. There will always be illegally uploaded sources on the internet. So at least here at Essex, what we always try to do is find a legitimate version of any potentially illegitimate sources. It is a difficult one. It is frustrating if there's something freely available there that students would likely be able to find on their own anyway. But we do have to think about the institutional risks with these kind of things. Okay, I'm going to skip that one actually. So we've got, it's very old, so copyright doesn't apply. So you found a resource and it's a very old resource, so copyright doesn't apply. Again, any thoughts in the chat if you want to explain your answer at all? So this isn't something I've touched upon in the presentation, but I thought it was something we could raise and discuss. So we'll end that one. So we've got it depends, and yes, you might notice it depends is very common when it comes to copyright, that yes, in this situation, it does depend. So within UK copyright law, 70 years after an author's death, written works in the UK are no longer covered by copyright law, but you must bear in mind that international laws differ, so that also complicates things a bit further. The rules also vary for other material. So for example, within the UK, broadcasts are protected by copyright for 50 years from the date the broadcast was originally made. So there's different copyright laws that apply to different types of materials, and also different laws across different countries. So it can be quite complicated. However, when materials are no longer covered by copyright, they're termed to be in the public domain. So for example, the original text from the Jane Austen novels would be in the public domain. The text of those works is no longer covered by copyright. However, the Penguin second edition of Pride and Prejudice is covered by copyright because that's a publication of those original words. So you couldn't just scan that whole Penguin second edition because that instance of that book is covered by copyright. The original words, the text, you could get on a PDF online because the text isn't covered by copyright anymore, if that makes sense. So there are kind of layers of copyright as well, which need to be considered too. Okay, so the final one, potentially an easy one to end on. No one will know and it will help my students, so it's fine to use. So we're thinking here about resources. You want to make a scan of a book. You don't think anyone will know. It's going to help your students, so it's fine to use. What do we think? So we've got full agreement this time. Nice one to end on. So no, this wouldn't be okay. I just wanted to end on this one. It's quite an obvious one, but I just wanted to kind of summarize everything from today. When it comes to copyright, as I said earlier, thinking about putting yourself in the shoes of the copyright owner is always really important. Creators of works are just people like you and I. We're all creators of work all of the time. So put yourself in the shoes of the copyright owner. If we think about this example of a book or a chapter or an article, for example, if you'd written it, you'd want other people to respect it. You'd have put a lot of work into it. Also, downloading a PDF of an article, for example, and then sending it around to all of your students can affect the author in terms of metrics. So they might be looking at how many times their paper's been downloaded, for example, how many times it's been viewed. If you've just downloaded a PDF and sent it to your students, that would affect those metrics. Also, on institutional levels, we at institutions have to think about the institutional risks. So the individual risk of you sending a PDF to all of your students, for example, or sending a PDF to all of your fellow researchers would probably be low, but there could be serious reputational and financial ramifications at the institution if everyone was doing this all of the time and it got found out. So just finally, on this point, copyright in general, and hopefully you'll have seen today from the publishing side and the teaching side, isn't intended to be a restriction. It's intended to protect the rights of the creators. As I say, all of us can and will and are the creators. So we want to think about how would we like our work to be used. We also encourage people to assert their rights as creators of work. So think about how you want your work to be used, and understanding copyright can help you to gain that power in having control over how your work's going to be used. You don't have to just read and sign every copyright agreement you're given. If you have a bit more understanding of it, you can make sure that your work is used and shared in a way that you're happy with. It might be that you want it to be used more widely than the standard copyright agreement allows, like, for example, using that rights retention strategy statement to retain the rights over that version so that you can make it publicly available in an institutional repository. Or it might be that a standard license is a Creative Commons attribution license and you want to add the share alike element or the non-commercial element. So having this kind of understanding of copyright will really help you in terms of compliance when we're thinking about teaching, but also in terms of knowing the exceptions you can use to broaden the resources that your students are able to access in a legal way. It can help you to protect your works in a way that you want and help you to feel confident with the decisions you're making when you're using third-party materials within your own research. So understanding copyright is really helpful. It helps you to get more use out of all the scholarly work that's out there and helps your work to be used more broadly as well. But that was a lot of information. Copyright can get quite complicated when we think about publishing and teaching. So I'm sure you guys have people that you can ask at your own institutions, but if anyone does have any follow-up questions, I'm more than happy for people to get in touch with myself and our research support team here at Essex if you want to discuss anything further. But also I will stop sharing my screen now. Hopefully you guys have got that email address. I'll just put it there in the chat as well. But I'll stop sharing my screen now. So if anyone had any questions that they wanted to put in the Q&A or the chat, I can answer them now as well.